Good afternoon, everybody. Welcome to this Farrar's Building webinar on causation in personal injury claims. My name, for those of you who don't know me, is Tom Bourne-Arton. I'm a member of Farrar's Building Chambers, and I specialise predominantly in large loss personal injury claims. In terms of today's talk, what I aim to cover during the talk is to cover all aspects of causation that you're likely to see within a personal injury claims setting. As a general outline, I plan to cover basic general principles, claims where there are or may be multiple causes, and then I'm going to go on and talk about the chain of causation and specifically focus on when the chain of causation can or cannot be broken. And then what I'm going to do is I'm going to move on to cases where there'll be a negligent omission, which is the breach of duty, and what you need to do in those cases, because we'll go on to discuss in due course, but they deal with hypothetical situations thereafter. And then finally, I'm going to get on to what I've called Fairchild causation, which is a special and exceptional type of causation for claims where there are multiple defendants and the scientific knowledge is not sufficient to say which caused the damage. Hopefully we'll have time to get on to Fairchild. We may not do. I haven't yet presented this talk, so I'm not 100% sure if it will take up the whole hour or whether it'll go beyond the whole hour. So time will tell. And I put Fairchild at the end because it's a fairly complicated special scenario, which in fairness could take a whole hour of discussion in any event. But we'll come on to that briefly, hopefully towards the end. In terms of timing, that also leads me on to comment about the question answer setup. Obviously, we're all familiar with these type of webinars now. There is a Q&A option within the webinar. You can type out your question. Now, if we have time at the end, I'll deal with any of those questions that are arisen. So don't think that I'm ignoring you. If you're writing a question during the presentation, I'm just going to deliver the presentation and then we'll come on to questions if we have time at the end. So that's just a basic plan of action for today's talk. And as promised, we're going to start off by discussing basic general principles. Now, obviously, normally the best approach in any claim is to consider breach duty first and then causation. Because without a breach duty, the claim will fail. Sometimes claimants will wrongly ask the judge to look at causation first and then use that as a basis to establish a breach of duty. And that approach can lead to errors in a judgment. For example, take a standard tripping accident type claim. Often the claimant will say to the judge, well, I was injured when I tripped on that defect. Therefore, that defect is dangerous, and that's the wrong way to look at it. What the judge should be asked to do is to assess, is that tripping hazard a real source of danger? And if the judge accepts that it is, then ask, did that real source of danger cause the claimant to trip, and then subsequently cause that claimant injuries? So that's the general approach that you should be adopting. There are some other basic points that are always sensible not to lose sight of. Generally, the burden of proving causation rests on the claimant and on the balanced probabilities. So in summary, what the claimant must prove is on balanced probabilities that the defendant's breach of duty resulted in the damage, and that damage is not too remote a consequence of the defendant's wrongdoing. Now, I'm not going to talk about remoteness of damage within this talk, because we simply won't have time to cover everything, including remoteness damage. And of course, remoteness damage isn't technically part of causation, but it is important not to lose sight of remoteness damage. And specifically, it's important to not lose sight of the question whether the damage complained of by the claimant is too remote for it to be just and reasonable to ascribe it to the defendant's breach of duty. Just a couple of other points before we move on to the next slide. If the claimant has the burden of proof and the judge is unable to resolve causation for whatever reason, then the judge doesn't have to go further and make a positive decision as to what was the cause. So the claimant can simply just fail for lack of proof. So the defendant doesn't have to establish an alternative cause. Now, obviously, most defendants will be assisted if they can say, not only was it not my breach of duty, it was actually caused by something else. But that doesn't mean that you have to, if you're a defendant lawyer. You don't have to prove what was the cause. You just have to make sure the claimant doesn't come up to proof themselves. Having said that, if there is a difficulty in establishing facts relevant to causation, the court may, in appropriate circumstances, infer that there is a causal link. So in a scenario where there is absolutely no possible other explanation, then an inference can be drawn. But of course, each case is very fact sensitive, and a judge will decide a case on the facts as appropriate. We'll come on to some specific cases where exceptions are allowed by the courts on grounds of policy and fairness. For example, certain causation scenarios in certain industrial disease type cases. But generally speaking, causation is only established when the claimant can prove the defendant's wrongdoing caused the injury in question, as compared to exceptional cases where the claimant only needs to prove, for example, an increased risk of injury. And the reason I mention this at this stage is it's important when we look at some exceptional cases, not to ascribe the same causative test in those exceptional cases to the general run-of-the-mill accidents. So, what's the test to apply? Now, I say test to apply. What we've got on this particular slide is the starting position. And the starting position is to apply the but-for test. What you're effectively doing is you're looking for the effective cause of the damage complained of and not irrelevant causes. The but-for test is the starting point, but it's not the starting and finishing point. As we'll come on to see, there's a couple of, a number of issues with the but-for test. But it's a good starting point because it's a test that acts as an exclusionary test. So what you should be doing is say, for example, would the injury have occurred in any event if the accident had not happened? Because if it would have happened in any event, the but-for test is not satisfied. So it excludes events that do not cause the injury. And really what we should be doing is asking, can the claimant establish on balanced probabilities, but for the defendant's breach of duty, the damage would not have occurred? And as I said, the reason not the starting and finishing question is because a lot of actions can satisfy the but-for test. For example, the claimant, just to take a completely extraordinarily obvious example, a claimant would not be in an accident at work if they didn't go into work in the first place. Now that might be a cause of the injury, but for the claimant getting out of bed, there wouldn't be an accident. But of course, that is not an effective cause of the accident. It's a cause, but an irrelevant one. So that would satisfy the but-for test, but obviously it's not. It doesn't actually succeed in establishing the getting out of bed as being a cause. So it's important to frame the question in light of the alleged breach of duty. It's always important to keep in mind what the alleged breach of duty is and consider causation in light of that alleged breach of duty. Just by way of an example, think of a situation where a school's risk assessment doesn't deal with the risks of being assaulted by challenging pupils. Now, if that's the factual background, would that breach of duty cause injuries to a teacher who was assaulted by a child who wasn't classified as a challenging pupil? Probably not. Ultimately, the test of causation relies on a judge taking a common sense approach to determine whether the defendant should be held responsible for the damage in light of their breach of duty. And I suspect a lot of litigators will say, well, which judges have common sense? But obviously, we rely on judges having common sense, and for the most part, they do. And causation really is repeatedly said by the Court of Appeal, a common sense test to be applied. I already prefaced the previous slide by saying sometimes the but-for test doesn't work. There are three semi-bullet points on this slide, which are good examples of where the but-for test doesn't work. Take, for example, a case where the defendant's negligence sets off a series of events leading to an injury. For example, someone who fractures their foot in an accident, who then has surgery and requires the use of crutches, and then many months later, but still in the process of healing, that claimant falls down a staircase due to the use of crutches and the crutches tripping them up, causing significant injuries. Now, is that second accident caused by the first accident? The first accident set off the series of events? The answer is probably yes. But you can see how there could be scenarios where something that happens 3 or 4 months later may not be within the series of events, or may not have been set off by that first act of negligence. So that can be an example where the but-for test doesn't necessarily work. Another example where the but-for test may not be of any assistance is where there are multiple causes that could all have been sufficient to cause the same injury. What do I mean by that? So the example I've thought up is take Caesar's death. Say when Caesar was stabbed to death, there were 5 people who all caused Caesar a fatal wound. Of the 20 or so who actually stabbed him, say there were 5 that actually caused the fatal wound. Each of those 5 dealt a deadly blow. Now the but-for test would exculpate all 5 on the basis that it couldn't be said the death happened but for that individual's stab, because of course there are 4 others. So that's a scenario where the but-for test doesn't work. And then the third example when the but-for test doesn't work or isn't of assistance is where the injury is caused by a combination of elements, but where more than the minimum required for the injury has occurred. So what do I mean that? The example I've got or thought up is, take someone who, before they decide to have an elective surgery, needs to have a majority of medical opinion to have that surgery. And then that same claimant has a multidisciplinary meeting with a number of the surgeons involved in the particular case, where 7 out of 8 of the surgeons give negligent advice to have the surgery. Now, obviously, that's more than the 5 that was required for the claimant to have the surgery, because the claimant would have had it if only 5 of them had given that advice, that negligent advice. So in this scenario, each individual surgeon's negligent advice would not satisfy the but-for test, because if only 1 provided negligent advice, then there would have been no injury, because there needed to be at least 5. But of course, there were 7. So that's another example where the but-for test isn't really of assistance. So the question really then, I suspect, that follows that is, how do you deal with causation in those situations? In a fairly recent case called Financial Conduct Authority, which isn't a personal injury case, it actually is a case that relates to business insurance payouts following COVID-19. It's a case that went to the Supreme Court, and this is why it's of use to personal injury lawyers, because it does at least set out an answer to the question in respect of the second and third scenario that we've been talking about. And what they effectively said, the Supreme Court, is that in the Caesar stabbing type scenario, where there are multiple causes all sufficient to cause the same injury, they said it would be manifestly not consistent with common sense principles for the loss to be avoided, and that each element can be treated as a cause. So that's how they say the second type of scenario should be dealt with. In the third type, where there's injury can only be caused by a combination of a number of elements, but where more than the minimum required have occurred, which is my medical negligence advice example. In that type of scenario, the Supreme Court said that each individual contribution is reasonably capable of being regarded as the cause of the harm, even if on their own, each element was not sufficient to cause the harm. So you can see how the Supreme Court have dealt with it, and you can see why policies of fairness and reasonableness and common sense are quite often used to justify getting a claimant to satisfy causation. Just whilst we're talking about where there's some difficulty with the but-for test, cases involving negligent omissions can cause difficulties, and we'll come on to those in due course. but just highlight at this stage the reason why, because if a failure to do something is the basis of the claim, then you have to ask what would have occurred if the proper action was followed. Then you have to delve into hypothetical scenarios. And said, we'll come on to that in due course. And finally, the but-for test is also not helpful where there's scientific uncertainty as to the cause. And again, we'll come on to examples where scientific uncertainty exists and the approach the courts have taken to causation in respect of those. And again, that'll be discussed in a bit more detail later on in the talk. But for now, what I want to get on to talk about is cases where there are multiple or potentially multiple tortfeasors. So a number of defendants in potentially liable. And I'm going to look at scenarios where there's more than one defendant who's actually liable, who has breached their duty of care, and to discuss what to do in terms of causation in those scenarios. Ordinarily, what the court will do is determine each defendant's breach of duty and apportion liability as is just in all of the circumstances of the case, given their respective blameworthiness and the causative potency of their breach. That obviously assumes that not only has there been a breach, but the defendants have also caused the injury in question. Where there are two or more defendants, and they are both liable, and there's no evidence to indicate the real proportion that the court should apportion it, then the court may divide liability equally, and they wouldn't be falling into error if they did that. Of course, in many cases, the defendant will be, or the defendants will be jointly and severably liable. And so it may have a scenario where the claimant hasn't elected to sue all of the potential defendants. And of course, in that scenario, a defendant can bring in a contribution claim if required. And of course, in those kind of cases, the claimant only needs to succeed against one to get the full quantum. Of course, there can be situations where only one defendant is liable, but it's impossible to say which. I say situations, I found it quite difficult to come up with any example other than the one that's on the slide, which came from a Canadian case called Cook and Lewis. It went all the way to the Canadian Supreme Court. But it does give a nice example of this. 2 bullets fired, one by each defendant, both negligently. Only one of the bullets hits the claimant, and it's impossible to say which defendant fired that bullet. So you can see it's a bit of a sort of interesting scenario, and one is difficult to replicate a different example. But anyway, what to do in that scenario? The Canadian Supreme Court said that where both defendants are negligent and the claimant cannot prove which caused the injury, the onus of disproving liability should be placed back on the defendants. And then if the defendants couldn't prove which one of them was liable, then the liability split should be 50-50, despite the fact that obviously only one of them could actually be liable for the actual harm because it only came from one bullet, which is quite an interesting case. Just moving on, just got a quick slide here on contributory negligence. This is really no more than an aid memoir, and just to remind people that in terms of burden of proof, the defendant has the burden of proving contributory negligence on the balanced probabilities. And of course, as a result, it needs to be pleaded in the defense. If contributory negligence is found, so if the claimant has, it's been accepted the claimant has caused the injury through his or her own negligence, then in terms of apportioning liability, the claimant's individual contributory negligence should be, the blameworthiness of that should be considered first, and apportionment of contributory negligence should take place first. Thereafter, whatever is remaining should then be divided and apportioned between the defendants in line with their relative blameworthiness. So, for example, if the claimant is 50% to blame for the accident, he or she will only get 50% of their damages as split between the defendants as appropriate. Just going to move on to situations where there is a chain of causation. And we talked about this earlier, and we talked about series of events scenarios, which obviously is the scenario which you have to have when there's a chain of causation scenario. I'm going to look specifically at when the chain starts and when the chain of causation is broken. In terms of when the chain starts, is it, as we discussed earlier, when the claimant gets out of bed? Obviously not. And if not, when is it between waking up and the accident does the chain start? Normally, it's fairly obvious when the chain of causation starts, and it's going to be with the breach of duty. But it's not always the case. The example I've got on the slide here is the case of Rouse and Squires, which will be a case that many of you, if not all of you, will be familiar with. But just to remind everybody, this was a case that was a multi-car pile-up case where the defendant who negligently caused their car to obstruct the highway in the first place, so as to make that a danger, was said to have contributed to the accident caused by the second defendant who negligently failed to avoid hitting that car and then leading into the injury. Now, what they said in this case was the test to apply is to argue, if you want to break the chain of causation, that is to argue that the subsequent driving broke the chain of causation by being reckless or deliberate. Now, if the second defendant wasn't reckless or deliberate, then the first negligence, creating the obstruction in the first place, still had a causative effect. So both defendants are negligent. I would just pause there and just draw your attention to another case, a more recent case. I'll say more recent, it's a 1999 case. So more recent, but still quite a long time ago. Is a case called Clift and Hawes. Now, in that case, what the court said is when there's ample visibility and ample opportunity for the driver of an oncoming vehicle to see and appreciate the nature and extent of the obstruction so as to take evasive action, then the obstruction does not constitute danger. And in such a case, there is a break in the chain of causation. Well, that may be described as a break of chain of causation, of course, but it may well be that there wasn't negligence in the first place. But if you have a scenario where there was a negligent act by a driver who causes an obstruction then that will be the start of the chain of causation, and there may not be a break in the chain unless there's been recklessness or deliberate action. But if there hasn't been an obstruction caused or the obstruction has been remedied, then it may well be that what then subsequently happens is not actually started by that initial event, and call it a break of chain of causation or just call it the chain not starting. Either way, that defendant that did the initial driving, it may not well be liable. Just as a defendant has to take the vulnerable claimant as they find them, which we all know is the eggshell principle, so too the defendant has to take the claimant as they find them if they have pre-existing injury or pre-existing damage to their chattel. It might seem obvious, but it's worth noting that a defendant is not liable for damage that's already caused, even if their actions would have caused the same damage. The example on the slide is a rather obvious one, but it makes the point. If a defendant drives into a collision with a claimant negligently, or claimant's car negligently, which would have caused that car to be written off, not liable if the car already was a write-off. It's quite an obvious point, but it's an interesting and useful point to just remember, because of course you can extrapolate it into scenarios where it's maybe not as straightforward. Anyway, in that scenario, the defendant obviously is not liable for writing up a car that's already written off. I'm going to move on now to a scenario where you'll all remember, which you'll all remember from law school, and that's the tension between the next two cases that I'm going to discuss. So the first one is on this slide, and that's the case of Baker and Willoughby. And then on the next slide, we have Jobling and Associated Dairies. Now, the tension between these two cases is where there is an apparent different approach taken depending on whether subsequent events are tortious or non-tortious. So let's start off with Baker and Willoughby. Now, in Baker, the defendant who caused an injury to the claimant's leg was liable for the difference between an uninjured leg and the leg injury that was caused. This was despite the fact that subsequent to the defendant's negligence, the same leg had to be amputated following the claimant being shot in the leg by robbers. What was that? The defendant wasn't liable for the losses caused by the amputation, but remained liable for losses caused by the difference between an uninjured leg and an injured leg, regardless of the subsequent event. And so in that scenario, that didn't apply the vicissitudes of life consideration that was applied in Jobling and Associated Dairies. Now, of course, in Jobling and Associated Dairies, the claimant's back injury, which was caused by the defendant's negligence, was overshadowed 3 years later when that claimant was diagnosed with myelopathy. And in that scenario, the defendant was only liable for the back symptoms for 3 years. And we'll see this type of scenario commonly in our own caseloads. For example, an accident which makes an asymptomatic back pain symptomatic 3 years earlier than otherwise would have done. Now, that obviously falls fairly and squarely within the Jobling and Associated Dairies type of case. And such issues are identified as being matters of quantum. The defendant isn't liable for things that happen after a breach of duty that would have happened in any event. Whereas in the Baker case, it was held that that was wrong as a matter of policy for someone's negligence not to be an effective cause of ongoing symptoms where there had further tortious acts had occurred. And of course, in Baker, lest we forget, the robbers had didn't identify who they were, and even if they did, they wouldn't have been able to pay for any injury. So that might have been the driver behind that particular case. But still, to date, if there's a tortious supervening event, that is to be treated differently to when there's a non-tortious supervening event. Going on to, or going back to even, talking about breaking the chain of causation, an intervening act may break the chain of causation by way of three methods, really. Acts by the claimant, acts by a third party, or acts of nature. Generally speaking, the question you need to ask is whether the act in question isolated, insulated, or eclipsed the original conduct such that it breaks the chain of causation. Those are the sort of words that are parried around by the higher courts when discussing what you need to establish a break in the chain of causation. In terms of natural events or an act of God, a good example is unusual, unforeseeable weather. Obviously, act of God as a phrase is often used as a defense to a claim, but if that act of God comes after the defendant's negligence or after the defendant's breach of duty, then it can be a novice actus interveniens. It can break the chain of causation, provided certain features that are there. Generally, did it isolate or eclipse the original conduct? Having said that, in this area, you're normally, if you're looking at breaking the chain of causation, you're normally going to be dealing with cases where there's an act of a third party which has broken that chain. As ever, very fact sensitive, and this is a particularly fact sensitive issue. There's obviously a sliding scale from those events clearly that don't break the chain of causation to those that clearly do. And somewhere along that line, a judge will accept or not accept that the act of the third party has or hasn't broken the chain. Rather obviously, but the more unreasonable conduct, the more likely it is to break the chain of causation. Negligent acts are more likely to break the chain than non-negligent acts, but that doesn't mean that non-negligent acts don't. And positive acts are more likely to break the chain than negative ones. Actors, looking at my next slide, I was reminded that actors often say never work with animals or children. Now, defendants may say never argue a breaking in the chain of causation caused by an animal or a child. And the reason they might say that is because it's difficult to establish a break in the chain of causation caused by either animals or children. As I say, preface that with saying it's not impossible, but it's just more difficult, but for obvious reasons. Where medical negligence occurs after the event, generally speaking, to break the chain of causation, that medical negligence needs to have been amount to gross negligence. Where you are relying on something that the claimant did, so you're not looking at, this is not a third party scenario. If you're the defendant and you're seeking to argue that the claimant broke the chain of causation, make sure her actions are not actually a defense to the whole claim, because it may well be if it was close in time to the breach of duty in question. Maybe, in fact, just an element of contributory negligence, but there again, it may not be. If after the breach, the act that you're looking at from the claimant is after the breach, then really it's got to be, the action's got to be so wholly unreasonable or have such an overwhelming impact that it breaks the chain of causation. So it's difficult for a claimant's conduct post-breach to break the chain of causation, but obviously not impossible. And just pausing there, and we're not going to deal with this until, obviously don't forget failure to mitigate as an argument for those defendants, lawyers out there. Don't forget the argument that a claimant has failed to mitigate their losses, which is a different consideration entirely. Finally, when considering the breaking of the chain of causation issue, there's 3 further points to make. If acting in an emergency or out of panic or in a rescue attempt, then it's very unlikely that those actions, excuse me, those actions will amount to acts that can break the chain of causation. So you might look at this, and the last 3 or 4 slides, I think, it's almost impossible to argue for a break of the chain of causation. And in truth, it is difficult, but not impossible. Going to move on to consider claims where the conduct complained of by the claimant is a negligent omission, and going to look at how to look at causation in such situations. These are cases where the claimant says she would not have been injured if the defendant had not negligently omitted to do or say something. And quite often you're looking at negligent advice in this scenario, or not providing advice. It requires considering what would have happened, either by the claimant, by the defendant, or by a third party. And we'll look at each of those in turn. So what would the claimant have done? Now, it's important in such scenarios, as in all scenarios for that matter, to make sure you understand properly the nature of the breach before considering what it caused. You then look at what the claimant would have done subjectively, not objectively. What would this particular claimant have done had they not had there been no negligent omission? It's a question of fact, but often it's made more difficult by the fact that most claimants will say, I would have done something differently and thereby not been injured, because that's the whole premise of the claim. And obviously it's in the claimant's interest to say that. Not many claimants, for example, say, well, I'd have been injured in any event. So obviously you've got to look at that with some clarity, both from the perspective if you're acting for the claimant and also if you're then faced with this type of case. Often the but-for test will be sufficient to establish causation in this scenario, but it may not be. And there's a good example where it won't, which is in relation to medical risk and omissions, negligent omissions to advise in respect of medical risks, which is what we'll come on to now. Informed consent has been a much litigated area in medical negligence claims in the recent past. Causation in such cases is a subjective test. So just exactly what I was saying a moment ago. It's subjective as to what the claimant would have done had she been given proper information. And an interesting question arises where you can ask whether a delay in having surgery has a causative effect. So in that situation, the case really to look at and start off is a case called Chester and Afshar, which is on the slide. It's an example where, had the advice been given properly, the claimant would not have delayed having the treatment. because the advice wasn't given properly, there was a delay, and then subsequently there was the treatment. And so when the claimant did subsequently have the treatment, this led to the small associated risk occurring. Now, was the negligent advice in that case a cause of the injuries? Well, the House of Lords split, but the majority said yes. And what they said is where there's a small random risk, where a small random risk is the result of the particular time and circumstances in which treatment is given, delaying that surgery would in all probability have meant that the small risk would not have materialized. So that's an interesting argument. Obviously, a policy consideration is at play here, and it works both ways. Whether, depending on if the negligent omission impacts on when the surgery would take place, and I say as policy consideration is clearly at play here, and that's indicated by the fact that the House of Lords was keen to stress that this is an exception to the general rule specific to negligent medical advice, and not to be used in any other situation. Most cases will involve asking what the claimant would have done but for the negligent omission. But you can have situations where it's equally relevant to ask, what would the defendant have done? What would the defendant's hypothetical conduct have been if there had been no negligent omission? And would that conduct have prevented the harm or not? So for the defendant to argue that breach of conduct would not have prevented the harm due to a hypothetical resulting actions, the defendant will have to establish that that damage would have occurred in any event. And that obviously involves asking what the hypothetical actions of the defendants would have been and whether they would have made any difference to the outcome or not. And the defendants would say, well, had I known this, had I done this properly, I'd have done this, and the action and the injury would have occurred in any event, despite the fact that I've taken some steps that I otherwise didn't. Again, subjective test to apply. A different approach is taken when considering what a third party would have done in a hypothetical situation. This is not an all or nothing scenario. So the courts have decided that an all or nothing approach shouldn't apply in such situations, but a loss of a chance should apply. Allied Maples group and Simmons involves a negligent omission in respect to professional advice. So it's not a personal injury case, but it's authority for this particular scenario. In that case, the defendant sought to argue that the claimant couldn't prove that the negligent omission, that if it hadn't occurred, that a third party would have provided an indemnity. So they're effectively saying that the same scenario would have occurred in any event, regardless of their omission, and the third party wouldn't have provided an indemnity in any event. The court held that where the quantification of losses depended on an assessment of future uncertain events, the court had to assess the likelihood of the risk materializing. AMG were entitled to succeed because they established there was a real and substantial chance and not merely a speculative one. So just to put this into an example, a different example, say there was a 40% chance of a third party acting in a certain way, which would then have caused the claimant's injury, and conversely a 6% chance of them acting in a different way, whereby the claimant wouldn't have suffered an injury. In that scenario, the claimant would be entitled to recover 40% of their losses. So a lot of a chance, similar to a lot of a chance type case. Moving on, and again, as previously promised when looking at the agenda, what we're now going to talk about is cases where there is scientific uncertainty, and specifically within industrial disease cases. Now, these cases are exception to the general rules, and a common exception to the general rules of causation exists where this scientific uncertainty as to the cause of an event. In such cases, the claimant only has to prove that there was a material contribution towards the damage. A material contribution causation can be used where there are cumulative causes and the science is such that the relative potency of the causes cannot be established. In such cases, the defendant is only liable to the extent of their material contribution. So think of somebody with noise-induced hearing loss. The defendant is only liable for the hearing loss caused by their breach of duty and the exposure to noise caused by their breach of duty, and is not liable for that caused by other defendants or for non-tortious causes. So it's important to note this type of attribution should be limited to cases where it's appropriate to look at causation through the material contribution test. Material contribution test is to be limited to cases where the injury itself is divisible, such as deafness. Because, for example, in deafness, you can become deafer as time, as exposure to noise increases, just by way of example. Material contribution test can't be applied where the injury is not divisible, where it's indivisible. So an indivisible injury would be something like a leg being cut off or certain cancers. So where you either have it or you don't. Material contribution causation can be used where exposure increases the actual harm, not where exposure increases the risk of harm. So it's the actual injury that's being increased by the exposure, not the risk of suffering the injury. Of course, the latter is exemplified in mesothelioma cases, and that's where we then come onto the case of Fairchild and the causation to be applied in that case. And as I've already promised, we'll come on to that in due course. Recently, courts have been tasked with considering if psychiatric harm is a divisible or an indivisible injury. Historically, the courts have found that psychiatric injury is indivisible, but that in any event, the material contribution test could still apply. So treated it as a specific example where the general rule was set aside and that the material contribution test could apply despite the fact that it was indivisible. However, more recently, it's been held that psychiatric injury is actually divisible, even if it is difficult to do so. In the case of BAE Systems, the Court of Appeal held, and I appreciate this is not on the slide, but I'll just quote what the Court of Appeal said. They said that the judge should try to identify a rational basis on which the harm suffered can be apportioned between a part caused by the employer's wrong and a part which is not so caused. I would emphasize, because the distinction is easily overlooked, that the exercise is concerned not with the divisibility of the causative contribution, but with the divisibility of the harm. In other words, the question is whether the tribunal can identify, however broadly, a particular part of the suffering which is due to the wrong, not whether it can assess the degree to which the wrong caused the harm. So looking at dividing the harm, the injury, not the risk of causing the injury. So you have a case where there are cumulative causes and science is such that the relative potency of the causes can't be established and the injury is divisible, then you can apply the test of whether the defendant's breach of duty materially contributed towards the injury. And then if you do so, look at the appropriate apportionment. We didn't talk about it beforehand. If I go back, the Holtby and Brigham-Cohen type apportionment to apply where relevant, based on the exposure of each individual defendant, or the non-tortious exposure as well, for that matter. What, however, do you do when the injury is not divisible, i.e. it's indivisible, and there are a number of defendants that could have caused the injury through exposure by their breach of duty, but you can't say which one actually caused the injury? Well, that was the question that arose in Fairchild and Glenhaven Funeral Services, and you'll all be more than well aware this was a case involving mesothelioma following asbestos exposure. The issue arose because there was a gap in the scientific knowledge and there were multiple defendants possibly liable. This is a different scenario to cases of asbestosis, because with asbestosis, there's a minimum dose of asbestos dust below which there's no risk of asbestosis. And thereafter, the severity of the condition increases with increased exposure. So it is a cumulative disease. Whereas with mesothelioma, one malignant cell in the lung causes a tumor. It's not a case where the severity of the harm increases with exposure, but it's a case where the risk of having the injury increases with exposure. The severity of injury doesn't. So contrary to the previous scenario, what you're looking at in this case is the risk of having the injury itself increases with exposure, not the injury itself. And it arises in situations where the medical science can't support the suggestion that any of the possible exposures by different defendants is regarded as more probable than any other. So with mesothelioma, there's no way of identifying, even on a balanced probabilities, the source of the fiber or fibers which initiated the genetic process which culminated in the malignant tumor. It just can't at the moment be proved on a scientific basis. So what to do? In Fairchild, the majority of the House of Lords held that in the special circumstances of this particular case, or this type of case, there should be a relaxation of the normal rule that a claimant must prove that but for the defendant's breach of duty, he would not have suffered the damage. I appreciate I'm slightly getting ahead of myself in the slides. Apologies for that. Just moving on. When can Fairchild be used? Obviously in mesothelioma cases, but can it be used in other type of cases? Well, the House of Lords restricted it to certain scenarios. Firstly, it has to be a defendant specifically intended to protect the employees from being exposed to that risk. And then 6 conditions have to be satisfied. Firstly, the claimant has to have been employed at different times and for different periods by both A and B, and even C, D, E, F, etc. So not just one employer. A and B have to be both subject to a duty to take reasonable care or to take all practical measures to prevent the claimant inhaling asbestos dust because of the known risk that asbestos dust, if inhaled, might cause a mesothelioma. And both A and B were in breach of that duty in relation to the claimant during the periods of the claimant's employment by each of them, with the result that during both periods, the claimant inhaled excessive quantities of asbestos dust. And then fourthly, have to establish that the claimant is found to be suffering from a mesothelioma. Fifthly, any cause of the claimant's mesothelioma other than the inhalation of asbestos dust at work can be effectively ruled out or discounted. And finally, sixthly, the claimant cannot, because of the current limits of human science, prove on the balanced probability that his mesothelioma was the result of his inhaling asbestos dust during his employment by A, or during his employment by B, or during his employment by A and B taken together. So it's quite tight for this exception of this exceptional test of causation that can be applied. The Fairchild principle can only be used to deal with scientific uncertainty. It can't be invoked just because proving the causal link is difficult. Similarly, Fairchild has no application to an ordinary case of personal injury consequent on an individual specific occasion of negligence for which a single party is responsible. In this situation, the court should just apply the but-for test, obviously on the balanced probabilities. And finally, Fairchild can't be employed to overcome scientific uncertainty in circumstances where the claimant has not suffered an actionable injury. I don't have a slide for this, but I think it's important to note that following up cases after Fairchild, some issues arose in respect of aspects of how it should be considered, and this led to Parliament enacting Section 3 of the Compensation Act 2006. And the Compensation Act Section 3 2006, Section 3 of the Compensation Act 2006 provides that, similar to Fairchild, so it provides the following: where a responsible person has negligently or in breach of statutory duty caused or permitted another person to be exposed to asbestos, and the victim has contracted mesothelioma as a result of the exposure, and it is not possible to determine with certainty whether it was that exposure or another exposure that caused the victim to become ill, and the defendant is liable in tort by virtue of the exposure in connection with damage caused by the victim by the disease, whether by reason of having materially increased the risk or for any other reason, the defendant should be liable in respect of the whole of the damage caused to the victim by the disease, and the liability is jointly and severably with any other responsible person. And the defendant's joint and several liability is irrespective of whether the victim was also exposed to asbestos, other by the defendant, whether or not in circumstances in which the other person has a liability in tort, or by the defendant in circumstances in which he has no liability in tort. That's obviously quite a lot to take on without a slide to read to set it out, but effectively, in other words, the defendant will be jointly and severally liable in a situation such as Fairchild itself, where all the other defendants were also liable in tort to the claimant, or whether defendants that aren't, and whether defendant has also been exposed to asbestos non-negligently by another person. So it's not a case of trying to attribute and do a percentage division, which you would get in those divisible injury cases where there is a cumulative impact. That is all we have time for. I'm amazed that without having done this talk before, I've actually managed to get it just within the 1 hour slot. I'm now, with some trepidation, going to look at the Q&A box to see if there are any difficult questions having been asked during the talk, and I can see that they haven't, which I think those of you who've done presentation before will agree with me is somewhat of a relief, because that's always when you get the rather tricky question that you'd rather a bit more time to consider. So all that leaves me to say is, if you do have a question which you didn't want to necessarily share with everybody who's on, then please email me. My email details are on the slides and there. And of course, you can contact the clerks with anything else that you need any help with. Other than that, just leaves me to say thank you very much for joining me. I hope it's been of some assistance, if not some interest. And oh, I've just seen that there's been a couple of questions. But that's quite all right, thank you. just thanks. That's always nice to see. But anyway, thank you very much, and have a very good evening, everybody.